Welcome to this explainer. Look, if you're navigating the business world today, you already know that commercial disputes, yeah, they're pretty much inevitable. But what happens when things actually go wrong? Do you immediately have to brace yourself for a lengthy, incredibly expensive, and highly public battle in a traditional courtroom? No way. Nobody wants that. So today, we're going to entirely demystify Uganda's Arbitration and Conciliation Act, Chapter 5. This framework is, quite literally, a game changer for businesses and investors. Why? Because it gives you a robust, legally backed toolkit to resolve commercial conflicts privately and way more efficiently. I'm going to guide you through exactly how this works, straight from the Act itself, so you know exactly what your options are when things don't go according to plan.
Okay, let's dive into this. Here is our roadmap for today. First, escaping the courtroom. Second, the arbitration process. Third, enforcing foreign awards. Fourth, the conciliation alternative. And finally, number 5, the dispute resolution center. Let's get right into it.
Section 1. Escaping the courtroom, exploring alternatives to traditional litigation. I want you to think of this act as your ultimate practical toolkit for entirely bypassing traditional litigation. And it all kicks off with one really high-stakes question. How do you solve a dispute without filing a lawsuit? Because let's be real, when your money, your time, and your crucial business relationships are on the line, the traditional public court system just isn't always the best fit, right? Well, the Act gives us 2 primary avenues to handle these situations privately. And understanding the core difference between them is absolutely foundational to everything else we're going to cover today. So first up, we have arbitration. As defined by the Act, you can think of arbitration as basically a private, formal tribunal. If you go this route, you are stepping out of the public court system, sure, but you're still asking a neutral third party, the arbitral tribunal, to hear your case and hand down a legally binding decision. It is formal, it's highly structured, and, this is key, according to Section 3 of the Act, the agreement to actually do this, it must always be in writing.
On the completely other end of the spectrum, we have conciliation. This is kind of the softer, more collaborative alternative. Instead of a tribunal handing down a strict, binding ruling on you, an independent and impartial conciliator simply assists both parties in trying to reach an amicable settlement. The outcome here relies entirely on mutual agreement. The conciliator is really just there to guide the communication and maybe propose some solutions, but the actual power to settle, that remains completely in the hands of the disputing parties.
Section 2. The arbitration process, from initial agreement to the final award. Okay, now that we know what our options are, let's move to and see how this builds through the actual life cycle of a dispute, exactly as it's laid out in Part 2 of the Act. Phase 1 is the agreement. Like I mentioned, it has to be in writing. Now, this could be a standard clause buried in your main contract, or it could be a separate document entirely. Phase 2 is appointing arbitrators. The cool thing here is the parties are totally free to choose the number of arbitrators and who they actually are. If they can't agree, an appointing authority steps in. Phase 3 is the hearing itself, where the tribunal decides whether to hold oral hearings for evidence or just rely on written submissions. And finally, Phase 4 is the arbitral award, which is the final written decision officially signed by the arbitrators. But a natural question here is, how do you know this private behind closed doors process is actually fair? Well, that brings us to Section 18 of the Act. This acts as the core philosophical principle governing the entire tribunal. It says, the parties shall be treated with equality, and each party shall be given reasonable opportunity for presenting his or her case. This is just a massive reassurance, especially for foreign investors or local business owners who might be a little skeptical. You are legally guaranteed a fair fight, and the arbitrators absolutely must be impartial and independent. Now, why does going through all these very specific steps matter so much? It's because of the ultimate finality of the outcome. Under Sections 35 and 36, an arbitral award is recognized as absolutely binding. Actually, scratch that. It's not just binding, it has total legal teeth. This isn't just a friendly piece of advice from a mediator. Once that award is handed down, and any time frame to challenge it has safely passed, it is enforced in the exact same manner as a decree of the High Court. Period. Section 3. Enforcing foreign awards. Global reach through international conventions. But look, business today is rarely confined to just one country, right? And this brilliantly illustrates the global reach of this act. Sections 39 through 47 ensure that international borders do not just stop dispute resolution in its tracks. If you have a domestic award made right in Uganda, as we just saw, it's enforced just like a court decree. But what if you want a massive arbitration in, say, London or Paris? Well, if it's a New York Convention award, meaning it comes from a foreign state that's party to the 1958 convention, Uganda is going to treat it as binding and enforce it locally. On top of that, if you're dealing with state-level investment disputes under the ICSID Convention, the financial obligations of those awards are executed just like a judgment from a Ugandan court. This creates a really secure, highly predictable environment for international trade. Section 4. The conciliation alternative, a flexible, amicable approach to dispute resolution. Pivoting completely away from strict formal rulings for a second, it's absolutely crucial to clearly contrast the two roles here. An arbitrator acts basically like a private judge. They look at the facts, they look at the law, and they hand down firm, binding legal decision on the substance of your dispute. But a conciliator, governed by Part V of the Act, they play a fundamentally different role. They act more as an amicable guide. Their entire job is to propose settlements, facilitate open communication, and ultimately help the parties reach their own agreement. They're guided by objectivity and fairness, sure, but they are never going to force a decision on you. Now, what's really interesting about this slide is the incredible strategic advantage conciliation offers to businesses. Section 60 of the Act mandates incredibly strict confidentiality for all matters relating to conciliation proceedings, and this even extends to the final settlement agreement itself. Think of it like keeping your secrets locked away in a vault. If you've got a dispute involving highly sensitive intellectual property or trade secrets, or maybe delicate supply chain relationships, conciliation ensures that all of your operational secrets stay completely off the public record. But please don't mistake this amicable approach for a lack of real power. You see that, number 1? Under Section 59 of the Act, if the conciliation is successful and the parties actually sign a written settlement agreement, that single document has the exact same status and effect as one binding arbitral award. Think about that. You get all the flexibility of a friendly, amicable negotiation, but that final signed piece of paper, it is the exact same formidable legal weight as if you had gone through the entire formal arbitration process. It's a best of both worlds scenario. Section 5. The Dispute Resolution Center, the engine room facilitating alternative dispute resolution. So you might be wondering, who actually manages all these experts and rules? Well, under Part 6 of the Act, the Center for Arbitration and Dispute Resolution, commonly known as CATER, is established as the official gatekeeper of quality. And according to Section 68, CATER has some pretty vital duties. Rapid fire here. They qualify and accredit the arbitrators and conciliators. They establish and enforce a really strict code of ethics, so you know for a fact you're dealing with real professionals. They maintain a comprehensive roster of experts, provide the necessary administrative services to support all these hearings, and they even offer training to promote alternative dispute resolution across the entire country. They are literally the engine that makes this entire act work in the real world. So the crucial point is that CATER isn't just some minor, overlooked bureaucratic office. It is a very serious, totally autonomous institution. The Act officially establishes it as a self-accounting corporate body. It's managed by a governing council, and we're talking heavy hitters here, like the president of the Uganda Commercial Court and key private sector reps, all working alongside an executive director. They have autonomous financial oversight, dealing directly with the ministry responsible for finance. Plus, they are subject to rigorous independent audits by the Auditor General, with annual reports that are mandated to be laid right before Parliament. This structure is entirely designed to ensure absolute integrity and accountability in the whole dispute resolution process. Wow, okay, we have covered a lot of ground today. The formal, binding power of arbitration, the massive global reach of international conventions, the incredibly confidential flexibility of conciliation, and of course the robust institutional support provided by CATER. Which leaves me with one final provocative thought for you to take away today. Looking at your very own business contracts right now, are you prepared to resolve your next dispute outside the courtroom? Because if you haven't audited your agreements recently to include arbitration or conciliation clauses, now is absolutely the time to start. Thank you so much for joining me on this explainer, and keep learning.